Hello and welcome to Freedom Watch, your daily dose of raw liberty online at foxnews.com. I'm Judge Andrew Napolitano here defending freedom, defending your natural rights, and defending your right to have a government that stays within the confines of the Constitution. Does the Second Amendment, which prohibits the government from infringing upon the right to keep and bear arms, only apply to the federal government, or does it apply to all governments? That's the question before the Supreme Court this week in the case of Chicago versus McDonald. When the Supreme Court decided Heller versus the District of Columbia last year, it made it clear that the right to keep and bear arms is an individual personal right that belongs to all persons, not just members of what once were called militias and now are called the National Guard. In my view, the Heller case, by calling the right to keep and bear arms a fundamental right, held that no government may infringe upon it. However, the Attorney General of the state of New York and the mayor of the city of Chicago disagree. Those jurisdictions have severely infringed upon gun rights, and the challenge to their restrictions was heard on Tuesday of this week in the Supreme Court. Lower federal courts have upheld the New York and Chicago restrictions. In my opinion, look for the Supreme Court to invalidate them. The Second Amendment, which protects the natural right to self-defense, would be utterly meaningless if states and local governments were not bound by it. Joining me now is one of America's staunchest defenders of the right to keep and bear arms, John Lott, author of the terrific book, More Guns, Less Crime. And also joining us is Ilya Shapiro, a senior fellow in constitutional studies at the Cato Institute and the editor-in-chief of Cato's Supreme Court Review. John and Ilya, welcome to Freedom Watch.
It's great to talk to you again.
Good to be here.
Ilya, first to you. Would it make any sense for any court to conclude that the Second Amendment only applies to the federal government? Wouldn't that effectively gut or eviscerate whatever protections we think we're getting from that amendment?
Well, that's right. I mean, technically, the Second Amendment does only apply to the federal government, but it gets incorporated or extended through other ways. But that's right. The right to keep and bear arms has to extend to everybody in the country, not just those living in the District of Columbia or other federal lands.
John, even though the First Amendment says Congress shall make no law, and then we know what follows: abridging the freedom of speech, interfering with the right to religion, affecting the right to travel. The courts have interpreted Congress to mean Congress, the president, the courts, the states. But the language of the Second Amendment doesn't refer to Congress. It simply says a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. As I read Heller, without getting too much into the weeds, the arguments this week in the Supreme Court are superfluous because Heller already said it's a fundamental liberty and therefore can only be interfered with under the most narrow of circumstances.
Well, I don't know how much stronger they could make it than use the term shall not. But courts, as you mentioned in the First Amendment, when it deals with things like campaign finance regulations or what have you, had adopted these balancing tests, that they've introduced all these gray areas into the discussion that I don't think the original drafters had any notion would ever be involved. In this case, obviously when the Bill of Rights was originally adopted, the notion was to restrict the federal government. As Ilya was saying, it's only been later after the Civil War that people began to think about applying those restrictions also to the states. But you're reading, not noticing that doesn't refer to Congress per se, is interesting. It's something that really hasn't been brought up very much in this debate.
Yeah. I guess the great virtue of Heller, Ilya, is the conclusion after 230 years that the right to keep and bear arms is an individual and personal right. It's not a collective right. It's not necessarily a right of the states. It's not just a right of militias. It's not just a right of National Guardsmen or women. It's a right that you and I and John Lott and all the people watching us, because we're human beings and we live in the United States of America, have and cannot be interfered with.
Well, that's right. And indeed, when we're getting to the 14th Amendment, which is the mechanism through which the right to keep and bear arms will be applied to the states, it's even more an individual right, because that amendment was put in after the Civil War to protect primarily the rights of freed slaves and unionists in the border and southern states who were being harassed and disarmed. And so that's a very important protection for self-defense. And I think the consensus is that one way or another, the court will rule to apply that right to the states.
John, you've done some interesting work with statistics, and your book, More Guns, Less Crime, it devastates the gun control argument. And I'm happy to reveal that another edition of that book with some very up-to-date statistics is about to come out. But tell us, please, about what happened with murder rates in the District of Columbia when the Heller case was decided and people in the District of Columbia were then allowed to arm themselves. And tell us, please, about murder rates in Chicago when McDonald was decided and nobody but the police in Chicago was allowed to carry a gun.
Well, nobody but police and some select politicians. But
no surprise.
It's the same pattern that you see worldwide. Every time that I've been able to study a gun ban being put in place, murder rates increase. You know, there's not one time where they even just stay flat. In the case of Washington, D.C., the D.C. handgun ban went into effect in February 1977. There's only 1 year after 1977 where the murder rate was as low in D.C. as it was in 1976, the year before the ban went into effect. That was 1985. Every other year it was higher. And it was just not rising relative to what D.C.'s murder rates used to be. It was rising dramatically relative to other city murder rates. If you look at the top 50 cities, in the years prior to the ban, D.C. regularly was bouncing around between about 25th and 15th in terms of rank, in terms of murder rates of the top 50. After the ban, half the years it was either number one or number two.
Ilya, why is it that the progressive mentality, uppercase P in progressive in the government, doesn't understand the unassailable and consistent statistics that show that the title of John's book is not just an eye catcher, but it's an accurate statement that more guns literally, figuratively, historically, and virtually without exception leads to less crime?
Well, Judge, it's the do it for the children exception to the Constitution that you might be less familiar with. All of Chicago's briefing and those of its friends that supported it were all these types of loosey-goosey public policy arguments that don't hold up under the weight of the statistical analysis that John's bearing, let alone under the constitutional analysis. I mean, we should go by the text. Those policy decisions were already made at the time of the ratification of the Second and 14th Amendment. The people who are for the gun control lobby and the gun restrictionists, it seems to be to them they can't get it in their mind that perhaps some of this might be counterintuitive, but indeed if you criminalize the possession of guns, then the only people who will have guns are criminals.
John, my worry is that the Supreme Court will decide McDonald in the correct way historically, constitutionally, and morally, which is that the Second Amendment restrains all government. But then it will allow the government to compel us to register guns. Now, here's my problem with registration. I don't have to register anything to express my First Amendment rights. I don't have to register with any government in order to express any other rights guaranteed by the Bill of Rights. And the first thing a tyrant does when the tyrant comes into office is to look at the list of who has guns and confiscate them. So again, what would the value of the Second Amendment be if I have to tell the government about every gun that I own?
Right. I mean, surely you're right about what's happened when different countries have required registration. Even in California, when they required registration of some assault weapons, those were later confiscated by the California state government. But you've seen it in England, you've seen it in Australia, you've seen it in many places. I think that there's another argument that can be made against registration because it's often phrased as a trade-off between freedom and safety that's here. And in fact, I heard you on Glenn Beck's show the other day where a woman had asked a question about that and said, well, shouldn't we just have registration just in order to help the police? registration doesn't help the police. We have Hawaii's had registration licensing for about 50 years. You've had Chicago. You've had Washington, D.C. You've had other countries like Canada. You go through Hawaii, Chicago, D.C., you cannot find one single crime that's actually been solved as a result of registration and licensing. If you look at Canada, they've had handgun registration since the 1930s. The Canadian government claims that they can point to 3 cases, and there's debate about 2 of those 3 cases, whether or not registration and licensing was useful in solving those crimes. And there's a very simple reason why it doesn't work, despite all the money that's been put into it, and that is, one, in theory, if a criminal leaves his gun at the scene and it's registered to the criminal, then you can go and trace it back to the criminal and arrest him. The problem is one, crime guns are virtually never left at the scene. In the few cases when they are left at the scene, it's either because the criminal's been either seriously wounded or killed, and so you're going to get him anyway.